Hello and welcome to Mississippi Insight. I'm Byron Brown. Thank you for joining us. This week, mandates and bans. Mississippi law faces court scrutiny and the media spotlight over COVID vaccinations, abortion restrictions, and voting rights. Legal analyst Matt Steffey joins us to discuss some key hearings coming up in the nation's highest court and a new initiative to monitor kids and protect them from digital threats. Can a major cell care and a tech safety firm keep up with growing safety and security risk online? That's all coming up on Mississippi Insight. First this morning, it's not just the nation-leading death rate from COVID-19 that has put Mississippi's governor in the national spotlight. Republican Tate Reeves has made a point to refuse masking and vaccine mandates to respond to this pandemic. And he openly questions the constitutionality of the White House's latest mandates. President Joe Biden ordered earlier this month that all federal workers must be vaccinated and that workers in companies with 100 or more employees must get vaccinated or submit to weekly testing for COVID. Governor Reeves responded on Twitter saying, quote, "The president has no authority to require that Americans inject themselves because of their employment at a private business. The vaccine itself is life-saving, but this unconstitutionality move is terrifying. This is still America, and we still believe in freedom from tyrants." So, is the governor right? Is the large company mandate unconstitutional? Who better to ask that question to than Matt Steffey? Matt is a constitutional law professor at Mississippi College School of Law. He's a frequent analyst on matters of law on 12 News. Matt, welcome back to Mississippi Insight.
Thank you. It's my pleasure to be here.
Matt, not only is the governor calling out the constitutionality of President Biden's executive orders on vaccinations, Attorney General Lynn Fitch is now joining about 23 other AGs in threatening to sue over the private sector mandate. Do we already have some major case precedents on this matter, particularly the 1905 Jacobson versus Massachusetts, the Supreme Court decision?
We do. It can get technical, the legal issues quite quickly. I think if we draw back, that the federal government, no doubt, has the authority to issue the kind of mandates we're talking about. What makes it more challenging is doing it on an emergency basis without the normal drawn-out rulemaking process. What President Biden has done is, through an executive order, directed federal agencies to issue standards and rules and directives to put these, implement these so-called mandates. That, in order to use the kind of emergency rulemaking process, there's an elevated standard. The threat has to be grave, and the action, the rule mandates, has to be necessary. And that standard is really the soil into which the 23 Republican governors are trying to bring a challenge. Now, I'm not sure the governors are the right party to challenge the mandate as applied to private companies, right? Because the governor isn't at the helm of a private company, doesn't work for a private company. One would expect the companies or their employees to bring that kind of a challenge. The mandate, as set out by President Biden, has four components. One applies to federal employees, one applies to federal contractors. Those seem to be on very firm ground. As an employer or as a person hiring independent contractors, the government has a great deal of latitude to set the conditions of employment or contracting. And so I think the government as employer and as contractor are on the firmest ground. Then there's a third component that hospitals and healthcare entities that receive federal money are also under this new directive. That's on awfully solid ground too. We'd have to look at the particulars. One of the things that makes this challenging now is we don't have the actual law yet. We don't have the emergency standard yet. We just have President Biden asking the agencies to put this into effect. But if it goes into effect as we expect, most observers think that the third component, the component that attaches more conditions to receiving federal health care money, is also on very solid ground. There's already a long list of conditions This seems quite reasonably related to the expenditure of healthcare money. The last component is the one we first mentioned, and that is the mandate as it applies to employers with 100 or more employees. If Congress passed a statute, or if this went through the normal rulemaking process, I think it too is on extremely solid ground based on the century-old precedent you mentioned involving, smallpox vaccine. But on this emergency basis, there's a higher showing of necessity, a higher showing of threat. But for heaven's sakes, 1 out of every 500 Americans has died in this pandemic. If that's not a grave threat, I'm not sure what is. I think if there's any legal vulnerability, it'll be in the details. What about people who are already had COVID? Do they need to get vaccinated anyway? Now, I do think as we hear vaccine mandate, but I think even that's a mistake. It's a testing mandate with essentially a vaccine opt-out, right? That there's no requirement that the employer sit there and put a jab in anybody's arm that refuses. They simply have to be subject to a weekly test. And it seems to me a weekly testing mandate for large employers is also on strong legal ground, assuming the standard takes into account, for example, people who work at home, people with allergies to the vaccines, maybe even people who have recently had COVID. There are going to have to be some exceptions, assuming the exceptions make sense. It seems to me quite necessary to address a grave risk, for example, to require that people who work shoulder to shoulder on a meatpacking line are either vaccinated or tested. But when we think about it as a testing mandate with a vaccine opt-out, it sure is hard to characterize this as a grave threat to liberty in the hyperbolic way our governor has stated.
On December 1st, the U.S. Supreme Court will hear oral arguments over Mississippi's law banning abortions after 15 weeks. Remind everybody what's at stake here.
Well, what is at stake, according to the brief of the Attorney General, is any right whatever to reproductive autonomy for women. The brief of the Attorney General argues that in order to uphold this particular abortion restriction, the Supreme Court can and should overturn Roe versus Wade. In fact, the brief is quite interesting. It is all about Roe and very incidentally about this particular law. It's almost as if this particular law is merely the one of many efforts to get the case in front of the U.S. Supreme Court with the avowed hope of retreating from Roe versus Wade and returning to the states the complete authority to ban and otherwise govern the reproductive freedom of women, at least the reproductive freedom of poor women residing in a poor state. Mississippi has one part-time abortion clinic that offers services early during a woman's pregnancy. For women that have, or their families that have, the means to buy a plane ticket or a bus ticket, or to have an overnight stay in another state, those women will still have access to abortion services. The families of our legislators, people who live of average means, the ability to travel, can still, as a practical matter, access reproductive health services, including abortion. These laws, these deeply restrictive laws, impact poor women. They impact women who live in abusive circumstances, who can't have an unexplained absence for 24 hours. They impact women without the transportation or the resources to get out of state. And so what it would do is it would eliminate abortion services in Mississippi, and people seeking them would have to go to another state or another country. That's what the state's asking for. That's what the stakes are. Now, many observers aren't sure whether the court will full on reverse Roe and completely reduce to zero the reproductive autonomy of women, the right to choose, or whether the increasingly conservative Supreme Court will continue to cut back on the Roe's protections. That whether it is Roe continues to suffer death by 1,000 cuts or is entirely overturned, I think is the question on the mind of observers. There's no doubt where the state stands. The state stands in favor of overturning Roe versus Wade, of returning to the Mississippi legislature the sole authority to decide on this matter. So this is for the proponents of the so-called right to life movement. The big objective of turning the clock back to 1970 in a world where legal abortions were available state by state.
The Supreme Court's vote to 5-4 this month to deny emergency appeal to Texas's new abortion law. That's the one that bans most abortions after 6 weeks, often before a woman knows that they're pregnant. What should we take away from that vote ahead of Mississippi's December hearing?
Well, I don't think it's good news for those for proponents of the right to choose. I think at some level it shows the court retreating from a role in vigilantly preserving Roe as precedent. Maybe it might mean that, or it may mean that this Texas law is so peculiar in that the state government doesn't have any role in enforcement, in that there are no criminal penalties like there usually are, that there's no case yet for the court to take up, not in the usual way the court does. So it might be a sign of its readiness to overturn Roe, and it might be a sign that the Texas law is just uniquely peculiar.
A lower federal court, the Fifth Circuit Court of Appeals, heard arguments this week on a voting rights case out of Mississippi. Our state currently sets a lifetime ban on voting for people convicted of certain felonies. It was enshrined in the 1890 state constitution. Talk about the felony voting ban and the arguments against it.
Well, the policy arguments against the felony voting ban are that it's too broad, too long, that once a person has paid their debt to society, they ought to be able to re-enter society and, among other things, vote. The constitutional argument against the lifetime voting ban is that there is no doubt whatever that ban was put in the Constitution in 1890 for purposes that specifically included disenfranchising African Americans, disenfranchising newly freed slaves and their families. And normally that purpose infects a law forever, right? That unless there is some superseding event that kind of resets the history, that if a law was enacted for a racially discriminatory purpose, and there's no doubt that the original 1890 constitutional provision was, and it continues to have that effect, and again, it continues to have a racially discriminatory effect, then it is presumptively unconstitutional unless the state can convince the court, and it may be able to do that subsequent modifications to the law have essentially cleansed the original unlawful purpose.
Big thanks to Professor Matt Steffey. Up next, digital parental controls and children's safety online. You're watching Mississippi Insight only on WJTV. And welcome back. We don't have to tell parents and grandparents out there that today's kids are tech savvy, connecting and will immerse in the digital landscape. That means that they'll face a wide range of digital risk. The telecom provider C Spire and an Atlanta-based online safety firm BARC are promoting new services to counter those risks to children. And joining me now is Titania Jordan. She is the Chief Parent Officer and Chief Marketing Officer at BARC Technology. Titania Jordan, Thank you for joining us to Mississippi Insight this morning. Thank you.
Thank you for having me.
First off, let's talk about the digital threat assessment for children. What particular risk are we talking about?
Wow, you know, it's really not a matter of if, but when your child encounters digital dangers. And that's anywhere from profanity to cyberbullying to online predation to mental health issues, acts of violence, drugs and alcohol, you name it, it's there.
What are your company and C Spire, what are you guys doing to counter those threats?
So Bark and C Spire have partnered to bring any C Spire wireless customer in the state of Mississippi Bark Junior for free, which will give parents access to filtering and screen time options. You know, when do you want your kid to access the internet and when do you not? You'll have that now in the palm of your hand for free. And then there's Bark Premium, which C Spire, thank you C Spire, is offering at a discount to any parent who wants to upgrade to use the monitoring suite of services that can alert you when your child has encountered a digital danger and give you best recommended next steps for how to address.
What does the customer have to do if they have that option?
All they have to do is go to cspire.com/bark, get your discount, sign up, go through the trial, and our team will help you.
Talk about the response from Seaspar customers since you've done this, and what's the reaction been from customers?
You know, what C Spire is doing in the state of Mississippi is groundbreaking, not only for Mississippi, but nationwide. You know, Bark is the best online safety solution for any parent that wants to help raise their child in a responsible way, help them grow into a responsible digital native. And we're saving lives. I mean, we have escalated over 1,000 online predators to law enforcement. We have helped to escalate over 285,000 severe self-harm situations involving children. You know, it's a lot. It's a hard time to be a parent. It's a very hard time to be a child, especially when they're spending upwards of 8 hours a day in front of a device. So much like you use a helmet when they ride a bike, you need to use Bark when they're on a device.
Does this include real-time monitoring from parents' phones?
Yes, so from my phone, I can get alerts for my 12-year-old, you know, when he encounters dangers in a text thread or online.
What have we learned through COVID with so many people on devices now because they've been either online learning or more on their phones during this last year and a half or so?
You know, the state of children and their mental health is very worrisome. The rates of suicidal ideation and depression and anxiety are on the rise, and their time spent online on social media is also on the rise. We, as parents, can't even begin to understand what it's like to be a kid today. Some of us haven't even downloaded the Snapchat app, yet our kids are in that app all the time. And so what we've learned is that parents have a long ways to go before they can fully understand, but what can't replace you know, effective communication is just that relationship. You have got to be where your child is. You might not want to spend time on that app or sit beside them while they're gaming, but sitting with them, learning it with them, asking them to show you how will teach you not only what they're going through, but help you see it through a parental lens so you can protect them.
Now, how wide of a net do you guys cover when it comes to covering social networks?
Yeah, so I'm glad you asked. So Bark covers over 30 social media platforms, as well as text messaging and email. So basically, wherever your kids are spending time on a device, we're there to cover you.
And so what's for parents who might be concerned,
yes,
what are you saying to them, or how do they even go about navigating and say, hey, I need some protection? How do they even know about it? How do they find this?
So if you're sitting here thinking, you know, I really need to do something else, I need to do something more to protect my kid online, you absolutely should. You need to go to cspire.com/bark, sign up for Bark Junior, Bark Premium, and get your children's devices and accounts connected and protected.
Yeah, the digital world is changing, and so so are the risks. So how do you assure parents and consumers that you can keep up with the evolving changes online?
Well, thankfully, it's not just a team of humans that are working at Bark, it's our algorithm. We use artificial intelligence and machine learning algorithms to keep up to date with the latest way that teens and tweens speak, whether it's actual words or acronyms or emojis, text overlay on top of a photo, audio, video. You know, our kids are brilliant and we have to keep up, but we humans can't keep up, but the machine learning algorithms can.
How fast do you see this growing, and how many, what's the goal for you guys as far as getting more parents using the the app for safety?
You know, the goal is less about a number and more about when everybody has heard of Bark, when parents have a more peace of mind when they give their child a device and not ooh, I hope they don't encounter this. That's the goal. The goal is education and empowerment and protection, because this is the first generation of parents that has ever had to parent in this sort of digital world. So we have to band together, and our children are a living experiment. We have to protect them.
All right, Titania Jordan, thank you for joining us.
Thank you for having me.
All right, and we'll be right back. Big thanks to Professor Matt Steffey and Bark's Titania Jordan for joining us this week. We'll be back next weekend with more of the political and current affairs coverage that you demand. I'm Byron Brown. From all of us here at 12 News, make it a great weekend.